In 1898, inside the probate court of New York County, a witness gave sworn testimony in a preliminary inheritance hearing. Yet the official minute book shows nothing. No entry, no summary, no trace. The case moved forward as if those words had never existed. This video examines how a record tied to the probate court of New York County could effectively vanish in 1898, and why a single procedural fact, a witness being officially heard in a preliminary hearing, matters when the official minute book later reads as if that testimony never happened. My mini-verdict is simple. If a sworn statement was taken in open procedure and the court's own ledger carries no footprint of it, then what disappeared wasn't noise. It was an intentional absence that changed what could be proven. The concrete anchor is the setting itself. The Lower Manhattan Courthouse Records Office, where minutes, filings, and certified copies were treated as the spine of inheritance law, and where a case can be advanced or quietly narrowed by what is allowed to become the record. What follows is an open loop with a clear promise. We will track how and why a single copy, a single acknowledgement, becomes the boundary between legacy and erasure. To understand the weight of that missing testimony, you have to step into the logic of New York at the end of the 19th century, when money didn't just buy property, it bought permanence. 1898 sits inside the long aftershock of the Panic of 1893, a period when fortunes were being restructured, family holdings were being shielded, and names that looked untouchable were quietly renegotiating risk. The Gilded Age elite understood something that modern viewers sometimes forget. A fortune isn't only what you own, it's what you can defend in public without opening yourself to scandal. And in that world, inheritance disputes were never merely private. They were reputational events. A contested will could become a headline. A witness could become a liability. A single statement, spoken on the record in the wrong tone, could give a rival family, a journalist, or a political opponent the one sentence they needed. The courthouse in Lower Manhattan was not a neutral building in the imagination of the city. It was a factory of legitimacy. Paper moved through hands with practiced speed, clerks indexing, assistants stamping, lawyers requesting certified extracts that could travel far beyond the stone walls. The minute book was supposed to be the sober instrument that kept this machinery honest, a bounded chronological account of proceedings, not an interpretation, not a rumor, but the official trace that something occurred. In an inheritance case involving a family whose social standing was as valuable as its assets, that trace was more than administrative. It was protective. It was the difference between "we heard this" and "you can't prove we ever did." Now place the starting point. An elite Gilded Age inheritance matter reaches a preliminary stage, and a witness is officially heard. Not a whisper in a corridor, not a private letter passed between counsel, an actual hearing moment with procedural weight. Whatever was said, it was said inside a system that knows how to preserve speech as fact. Yet afterward, in the place where such moments should be pinned down, the official book of minutes, there is total absence. No line acknowledging the witness, no brief note that testimony was taken, no summary, no routine entry that would, at minimum, confirm the hearing's scope. The process continues cleanly, as if the testimony never occurred at all. That is the central tension. The city's legal machine functions and the case proceeds, but the memory of the proceeding is selectively silent. In an era when the press had both appetite and influence, silence is rarely accidental. Newspapers in the 1890s could amplify a probate fight into a public spectacle, and the families who lived by social standing treated public narrative like an asset class. You didn't only manage your investments, You managed what the city believed about you. A probate dispute risked becoming a story of greed, illegitimacy, betrayal, or hidden relationships, stories that could haunt a family's standing long after the estate was settled. And the legal system, staffed by humans with careers, connections, and pressures, existed inside that same social atmosphere. So the question becomes narrow, practical, and therefore dangerous. What does it mean when the system recognizes an action, hearing a witness, but the official memory mechanism refuses to acknowledge it? It means that the fight is no longer just over property. It is over what can be cited, what can be appealed, what can be referenced later when someone asks years afterward, what exactly was said before the court decided? It means the battlefield shifts from argument to archive, because in probate law, what survives is what can be pointed to, and what cannot be pointed to becomes, legally speaking, easier to dismiss. If you've ever wondered whether a ledger, a registry, or a minute book can act like a gate instead of a mirror, ask yourself this: which door in that records office decides what becomes real? And if this intrigues you, leave a like and subscribe so you don't miss the next file. We are not going to solve the mystery in the introduction, and we are not going to pretend this is a story about theatrical conspiracies. This is about a simpler, colder possibility that a decision was made inside an ordinary institutional process, and that decision produced an extraordinary outcome, an absence where a trace should be. In 1898 in Lower Manhattan, reputations were defended as fiercely as assets, and the cleanest defenses were the ones that never looked like defenses at all. By the time the hearing ends, the case advances with the calm momentum of bureaucracy, the kind that makes everything feel inevitable. But inevitability is often manufactured, one omission at a time, until the future has only one official path to follow. And when you finally picture the scene that matters, it isn't a dramatic confrontation. It's a clerk's desk, a bound ledger, and the quiet finality of a page that should have held a name, a date, a witness, yet holds nothing. Because the most unsettling question is not what the witness said. It's why the record was prepared to act as if the witness never spoke, leaving behind only the physical certainty of the space where the testimony should have been, and the cold, blank surface of an official book of minutes. In 1936, the first thing that changed was not the case itself, but the way the courthouse began to look at its own paper. Inside the surrogate's court archive division, a routine consolidation of old material brought attention to holdings that had never been fully processed. The work was procedural. Shelves were cleared, cartons were opened, bundles were separated, and stacks of supporting transcripts, materials that were never meant to be the official story, only the working residue of it, were pulled into view. In the middle of that effort, an employee opened an uncatalogued box of auxiliary transcripts that carried no clear accession tag and no reliable index entry. The contents were mixed, out of sequence, and not stamped in the way docketed records usually are. There were typed pages folded into thirds, loose sheets with faint clerk initials, and partial transcript runs that did not match any single, bound volume. The concrete action in that moment was simple and unglamorous. The employee separated one thin typescript from the rest because it read like a complete excerpt rather than a fragment. It was a single copy, on its own, with no protocol number printed at the top, no docket reference in the margin, and no filing stamp that would normally anchor it to a case jacket. And yet the text, line by line, carried the rhythm of a real proceeding. It identified a preliminary hearing. It preserved a formal sequence of questions and answers. It used the same legal phrasing that appears in official courtroom practice: sworn capacity, counsel identification, and the careful cadence of testimony taken for the record. It did not announce itself as rumor or private memorandum. It read like something meant to exist inside the machinery of court procedure. What made the document immediately strange was not what it claimed, but how confidently it spoke in the language of the court while lacking the physical signals that make a record belong to the system. In a New York courthouse of that era, even secondary materials typically carry a trail, a docket number, a clerk's file mark, a reference to a minute entry, an internal routing notation. This typescript had none of that. No protocol number, no filing stamp, no cross-reference. It was, in archival terms, free-floating. Yet its wording was not generic. It referred to the institutional setting with specificity, matching the procedural tone expected of a preliminary hearing in New York County. It placed a witness in the position of being officially heard. It preserved the formal framing that would normally appear only if someone had been tasked to capture testimony as testimony, not as narrative. The archive staff did what clerks do when a page does not fit. They checked it against the system that should have absorbed it. The minute books were the first stop, because minutes are where proceedings leave a footprint. Even when transcripts are incomplete, when the employee compared the content to the bound minutes connected to the 1898 hearing window discussed in the case file, the contradiction was immediate. The minute book treated that phase of the inheritance matter as clean and forward-moving, with no mention of the witness whose words appeared on the stray typescript. There was no summary line, no notation that testimony had been taken, no entry that a witness was sworn. Nothing that would justify the existence of a transcript-like copy, especially one written in language consistent with official examination, sitting loose in an auxiliary box nearly 4 decades later. The discovery did not require interpretation to become consequential. The paper itself established a factual tension. Either the typescript was an artifact of a real court action that was never reflected in the official minutes, or it was a copy created outside the ordinary protocol that had somehow migrated into court holdings. Without being docketed, the Archive Division did not need a theory to recognize the first problem. If the witness testimony occurred in a preliminary hearing, the complete absence of any minute trace was not a minor clerical gap, because minutes are designed precisely to prevent a proceeding from becoming deniable. A court system can lose pages, miss file attachments, or damage bindings, but it rarely produces a record that reads like an official excerpt while leaving no administrative shadow. That is why the document should not exist in the form it was found. A transcript-style copy without a protocol number is not how official memory is normally kept. It is how fragments survive when the normal chain of custody has been interrupted. The archive staff treated it as an anomaly and performed the next concrete action available to them. They set it aside, logged it as an item requiring verification, and attempted to locate any matching transcript series or supporting clerk notes that would explain its presence. Nothing in the immediate holdings resolved it. No corresponding protocol, no case jacket insertion, no index card bearing a summary. The copy remained singular. The effect of that singularity is where the consequence becomes real. Up to that point, the story of the 1898 hearing could be framed as an absence with plausible deniability. Perhaps the witness was mentioned elsewhere. Perhaps the minutes were incomplete. Perhaps the record-keeping was simply imperfect. In 1936, that posture became harder to maintain because the court's own environment produced a surviving textual object whose legal language aligned with the very proceeding the official minute book refused to acknowledge. The omission was no longer just a blank. It had an opposing weight. An absence can be shrugged off. A surviving copy cannot be ignored as easily because it creates a question the institution must answer, even if it answers it silently. What defines the legal existence of a fact? What was said or what the system agrees to record? The document did not solve anything. It did not explain the mechanics of omission. It did not reveal a motive on its face, but it created the first tangible proof that the case proceeded through a narrowed version of reality, and that at least one strand of the fuller reality survived outside the official minute line. In practice, that shifts the legal and institutional stakes. If a witness was officially heard, and that fact can be evidenced, then subsequent actions taken as if the testimony never occurred rest on a record that is demonstrably incomplete. That can affect how an estate narrative is defended, how reputational claims are insulated, and how later reviews of the file are constrained, because what can be cited as official history becomes a choice rather than a mirror. The block ends where the archive worker's hand would have paused in real life, because the next step is not discovery, but responsibility. A lone, protocol-less typescript with courtroom language cannot simply be shelved like a newspaper clipping, and it cannot be treated as a normal transcript without anchoring it to the official chain. In 1936, inside the surrogate's court archive division, the copy was placed flat, separated from the mixed stack and held in a temporary sleeve, paper inside paper, waiting for someone to decide what to do with a record that reads official, lacks a number, and contradicts the minute book. Between 1890 and 1905, the danger was not created by a single corrupt act or a single powerful family, but by the environment in which wealth, law, and reputation were structurally intertwined. In New York, at the height of the Gilded Age, inheritance was not a private transfer of assets, it was a public confirmation of hierarchy. Old money families understood that estates did more than distribute property. They stabilized alliances, validated bloodlines, and preserved a social order that depended on continuity, appearing natural. A contested inheritance, especially one involving testimony that hinted at internal fracture, could ripple far beyond the courtroom. It could alter how a family was received in banking circles, philanthropic boards, and political clubs. The legal system did not operate outside that reality, it operated inside it. During this period, probate courts were theoretically administrative spaces, tasked with validating wills, inventories, and transfers according to statute. In practice, they were points of contact between formal law and informal power. Judges, registrars, and clerks were civil servants, but they were also residents of the same city that read the same papers, attended the same social functions, and relied on the same reputational economy. The risk attached to a single inheritance case was not limited to who received which parcel of property. It included whether dormant disputes became visible, whether previously private arrangements were exposed to scrutiny, and whether a family's internal discipline appeared to falter in public view. The press amplified that risk. Newspapers such as the New York Herald treated elite inheritance disputes as legitimate news, not gossip. A probate hearing could become a front-page item if it suggested hypocrisy, hidden heirs, or impropriety. In the 1890s, journalism was increasingly aggressive, and editors understood that readers were fascinated by the internal mechanics of wealth. A witness's sworn words, if recorded and reported, could be lifted from the courtroom and reframed as narrative, a story of betrayal, manipulation, or moral failure inside a household that claimed respectability. Once printed, such narratives were difficult to contain. Retractions were rare, and silence was often read as confirmation. For families whose power rested on the perception of order, this was a serious threat. Because of this, the elite developed parallel practices for managing risk. Formal litigation was only one layer, Beneath it existed a culture of silent resolution, an expectation that disputes would be narrowed, redirected, or settled before they reached a point where the public record became volatile. This did not always involve explicit illegality. More often, it relied on informal pressure, conversations between counsel, suggestions passed through intermediaries, and expectations communicated without leaving written traces. The goal was not to erase the law, but to guide how the law appeared. To operate, a proceeding could move forward, a judgment could be issued, and an estate could be closed, all while certain destabilizing elements were quietly neutralized. One of the most effective tools in this environment was control over what entered the public record. The record was not just evidence, it was a signal. Anything formally inscribed, minutes, transcripts, filed exhibits, acquired a life beyond the case itself. It could be cited years later, revisited by journalists, or reopened by rival claimants. Conversely, what never appeared on the record was difficult to resurrect. It might be remembered privately, but legally it was weightless. For families invested in long-term stability, this distinction mattered more than the immediate outcome of a hearing. Winning an inheritance battle was less important than ensuring that the victory did not carry a visible scar. This is where informal pressure on courts and registrars enters the picture as a concrete action rather than an abstract accusation. In the period between 1890 and 1905, it was common for influential attorneys to communicate concerns about unnecessary exposure to court officials. Registrars were reminded of the administrative burden of detailed minute keeping. Judges were encouraged to keep proceedings focused and efficient. None of this required a written directive. The pressure was social and reputational, operating through shared assumptions about what was appropriate for public documentation. A witness whose testimony threatened to complicate an estate's narrative could be heard, acknowledged, and then effectively minimized by how or whether that testimony was memorialized. The danger of this system lay in its plausibility. From the outside, everything could appear orderly. The court functioned, orders were issued, property changed hands. There was no obvious rupture that demanded investigation. Yet within that order, omissions could reshape reality. A line not entered into a minute. Book was not merely absent. It altered the legal landscape for anyone who came later. It limited what could be challenged, appealed, or even questioned. Inheritance law relies heavily on precedent and record. When records are selectively thin, they channel future interpretations along a narrower path. For old money families, this narrowing was protective. Alliances were often built through marriage, shared investments, and mutual reputational defense. A public inheritance dispute that exposed internal conflict could weaken those alliances. Banks might hesitate. Philanthropic partners might distance themselves. Political favors could become more expensive. The cost was not immediate bankruptcy, but gradual erosion of influence. That is why the consequence of public registration was so severe. A single documented irregularity could destabilize relationships that depended on the appearance of seamless continuity. The risk extended beyond individual families to institutions themselves. Courts depended on public trust. They were expected to be neutral, but they also operated in a city where power was unevenly distributed. If a probate court became known as a place where elite disputes routinely exploded into scandal, it risked becoming a battleground rather than an administrative forum. Managing visibility was therefore in the institutional interest as well. Silence could be framed as efficiency. Brevity could be defended as professionalism. Over time, these justifications hardened into habit. By the early 1900s, this environment produced a specific kind of tension. On one hand, the law demanded procedures that were, in theory, transparent. On the other, the social cost of transparency was high. The system resolved this tension not by openly defying the law, but by exploiting its discretionary spaces. Minutes could be concise, transcripts could be limited, certain elements could be treated as ancillary rather than central. Each individual choice was defensible. Collectively, they created a pattern in which sensitive facts were less likely to survive as official history. The real danger then was not exposure in the moment, but survival over time. A damaging testimony spoken once could fade if it was not anchored to the record. Decades later, when memories dimmed and participants died, only paper would speak. Families who understood this played a long game. They focused less on immediate outrage and more on archival permanence. The cost of reputational damage was measured not in headlines, but in what future generations could prove. This context explains why a single unrecorded testimony in 1898 was not a clerical curiosity, but a threat. It existed at the intersection of law and reputation during a period when both were fiercely protected. Allowing such testimony to remain visible in the public record risked converting a manageable internal dispute into an enduring external question. Removing or minimizing its trace reduced that risk. Dramatically, the alliances remained intact, the estate could be normalized, the social order held. By the time the century turned, this mode of quiet management had become familiar to those inside the system. It did not announce itself as interference. It presented itself as discretion. And in that discretion, choices were made, often without written instruction, about what deserved to last. The scene to hold in mind is not a dramatic confrontation, but a courthouse corridor at the turn of the century. Conversations lowered in volume, papers adjusted on a desk, and an understanding shared that some things were better resolved without becoming permanent ink. The next step in the story is not discovery or exposure, but the moment when discretion hardens into action, when someone decides how the record will ultimately remember what happened. In November 1898, a few weeks after the preliminary hearing, the case did not change in open court. It changed in the space that controlled what the court would later be able to remember. That space was the court clerk office in the Lower Manhattan courthouse, where proceedings were converted into the official record through routine clerical steps that rarely appear in public narratives. The public assumes a hearing becomes history automatically. In reality, it becomes history when someone takes the raw materials of the day, bench notes, shorthand fragments, counsel names, the sequence of appearances, and decides what will be entered into the bound minute book that the institution treats as definitive. By that point in the 1890s, the workflow was stable. A preliminary hearing could generate multiple layers of paper, a clerk's running notes, a stenographer's shorthand, an internal draft meant to help later transcription, and then the final minute entry that was copied or written into the official book. The key is that the official minute book was not a live transcript. It was a curated product. It could be concise, and it often was. It could compress a complex exchange into a procedural sentence, but it was still supposed to acknowledge what took place. A witness being sworn and heard was the kind of procedural fact that normally left at least a minimal trace, if only because it affected what could later be raised, challenged, or appealed. The surviving problem in this case is not that the witness testimony was summarized poorly, it is that it is not acknowledged at all. For that to happen, the absence has to enter at a very specific point in the chain, the moment when someone responsible for the minutes decides that an event will not be written into the official record. And in 1898, that decision did not need a dramatic conspiracy to occur. It could happen through a small administrative meeting out of session inside the clerk's office under the logic of cleaning the record narrowing exposure and keeping the file from becoming combustible in the press. The reason we can speak about a decision, even without a surviving written order, is that the court's own procedures require one. Minutes do not omit a sworn witness by accident and still remain internally consistent. If a clerk simply forgot an entry, the surrounding paperwork usually exposes the oversight. A reference elsewhere, a notation that a witness appeared, a trace that something happened that the minutes forgot to memorialize. Here, the absence is total, and the case proceeds as if the testimony never had procedural weight. That is, not the signature of negligence. It is the signature of an instruction given in the language of administration rather than emotion. Picture what instruction looks like in this environment. It is not a signed memo. It is a conversation held behind a desk with the file open, a deputy clerk present, perhaps a senior clerk whose job is to keep the minute books consistent and the docket moving. The courthouse is busy, and the office is not designed for drama. It is designed for throughput. In that setting, a decision to omit can be framed as a matter of efficiency. The testimony is not necessary for the minutes. The hearing is preliminary. The entry should reflect the disposition rather than the exchange. Each phrase sounds reasonable in isolation. None of them admits what it accomplishes. Together, they create the mechanism by which a sworn statement can be treated as administratively irrelevant. The crucial detail in this topic is that the meeting is internal and out of public session. It happens after the hearing, when the immediate public attention has already shifted. The timing matters. If the risk was reputational, and in 1898 for old money families it often was, then the best time to reduce that risk is not in the courtroom, where eyes and ears are present, but afterward, when the only audience is the institution itself. That is why the court clerk office is the right locus for intervention. The clerks are the gatekeepers between what happened and what can later be proven to have happened. The action, in concrete terms, is not complicated. The testimony is not inserted into the official minute book, not summarized differently, not moved to another volume, not entered under a different caption, simply omitted. The official record is allowed to remain silent on the witness's appearance, so that when anyone consults the minutes later, an attorney, a reporter, a rival claimant, a future court, the witness does not exist in the court's formal memory. In the institutional logic of probate, that silence has weight. It changes what can be raised as part of the official proceeding. It changes what can be cited as having occurred in open process. It narrows the case to what is convenient, defensible, and socially survivable. What makes the decision especially effective is the way authorization works in bureaucracies under pressure. There does not need to be a written order, because the system often moves on verbal cues and implied permission. A senior clerk does not have to write, "Do not record the witness." The senior clerk has to communicate a preference and let procedure do the rest. The preference can be voiced as a question, "Do we need that in the minutes?" or as a statement, "Keep the entry clean." It can be delivered with the assumption that everyone understands what clean means in a sensitive file. And when the minute clerk later prepares the official entry, the omission appears not as sabotage, but as professional discretion. This is how an absence becomes defensible. If challenged later, the office can always claim that minutes are summaries, not transcripts. It can claim that preliminary exchanges are often not detailed. It can claim that the official book reflects only what was required. And because there is no written instruction, there is no document to subpoena that says explicitly, "We chose to erase." The choice is embedded in the final product, a page that contains the court's voice, minus the one element that could complicate the legacy, The absence is the order, the consequence is immediate and real, and it is not philosophical. When the testimony is not in the official minutes, it loses legal force in the way that matters most. It becomes difficult to invoke as part of the formal proceeding. Attorneys can argue about what really happened, but probate practice depends on what the file can support. Appeals are built from what the record shows. Challenges rely on what can be cited. If a witness's testimony cannot be anchored to the minute book, it can be treated as external, unofficial, or merely auxiliary. That classification changes everything. It reduces the testimony from a procedural fact into a disputable artifact. It becomes easier to ignore, easier to reframe, and easier to keep away from any public narrative that might form around the case. This is also how the case can continue as if the testimony never occurred, without requiring anyone to lie openly. People do not have to deny the witness was heard. They simply consult the minutes, and the minutes do not acknowledge the witness. The institution then behaves consistently with its own written memory. The estate moves forward. Transfers proceed. The file stabilizes. The public record remains calm. In a city where the New York Herald and other papers could weaponize probate disputes, calm was not just desirable, it was protective. There is another reason the clerk's office decision matters. It creates a split between two kinds of records. One kind is official, bounded, indexed, and designed to be cited. The other kind is residual, notes, drafts, auxiliary transcripts, paper that can survive without being recognized. The decision in 1898 forces the witness testimony into the second category. It pushes it into the realm of the survivable but deniable. That is how a single copy can later resurface in 1936 in an uncatalogued box, speaking in court language while lacking the official anchors that would normally guarantee its legitimacy. The 1936 discovery is not an isolated miracle. It is the downstream effect of a classification choice made in the clerk's office decades earlier. None of this requires assigning villainy to a single name. The system does not need a single villain to produce a deliberate omission. It only needs a moment when institutional incentives, reputation, efficiency, pressure, the desire to keep elite disputes from spilling into the record, align. With discretionary control over documentation, in 1898, that alignment was common enough to be invisible to outsiders. To insiders, it could be framed as prudence, as restraint, as keeping the court from becoming a stage. The investigation advances here because it identifies the exact hinge on which the entire case turns. Not the hearing itself, not the witness's words, but the conversion of event into record. Once that hinge is acknowledged, the later chain becomes trackable. A decision to omit does not end the story. It sets the conditions for what must happen next in the material world. If testimony is kept out of the minutes, then the paper that captured it has to be handled somehow. It has to be placed somewhere. It has to be treated as something other than the record. That handling is where the next topic begins, because the decision is only the first move. The next move is the physical adjustment that makes the decision durable. The closing image is the one that matters, because it is ordinary. A bound minute book lies open on a clerk's desk under courthouse light. The date line is in place. The entry for the proceeding is written with administrative calm. And where a sworn witness should have left a procedural trace, the page stays clean, ink set, margin unmarked, the silence made official. Between 1898 and 1899, the decision taken inside the clerk's office had to be translated into something durable, something that would survive routine scrutiny without drawing attention. That translation occurred within the records maintenance department, the unit responsible for turning a working file into an archive that could be consulted years later with confidence. This was the point where discretion became structure. What had been an internal preference, what should and should not appear, was converted into a physical and administrative reality. The alteration did not announce itself as an intervention. It took the form of standard maintenance. Files were reviewed. For completeness, minute entries were finalized. Drafts that no longer served a purpose were sorted. In probate practice at the turn of the century, this was normal work, especially after a sensitive case reached procedural closure. But in this instance, the work produced a specific outcome. The final minute entry was rewritten to reflect a streamlined version of the proceeding, one that acknowledged the hearing's administrative milestones while omitting any reference to the preliminary testimony that had complicated the file. The rewritten entry did not contradict the law. It complied with it narrowly. It recorded what the department deemed necessary and excluded what it deemed expendable. This mattered because the minute book was not merely a summary. It was the gateway. Researchers, attorneys, journalists, and later courts would begin there. The absence of the testimony from the final entry meant that, from the perspective of the official archive, the witness had no procedural existence. The alteration was therefore not cosmetic. It changed how the case could be encountered and understood. Anyone consulting the minutes would see a clean progression, a hearing, administrative steps, and a forward-moving disposition. The risk-laden element, the sworn testimony that had once entered the room, was now structurally invisible. The second part of the alteration addressed the residue. Testimony generates paper, and paper has a way of persisting unless it is deliberately handled. The auxiliary copy, the one later discovered decades afterward, was not destroyed. Destruction would have created its own risk, especially in a department accustomed to audits and internal checks. Instead, the copy was archived outside the official index, placed among supporting materials that were not keyed to case names or docket numbers. This was a subtle but decisive action. Indexes are not neutral tools. They define what can be found. A document that exists without an index entry exists in a practical sense only by accident. By removing the auxiliary copy from the indexed path, the department ensured that the document could not be retrieved through ordinary inquiry. There would be no card to pull, no reference to follow, no predictable trail leading from the minute book to the transcript-like pages. The copy was not labeled as false, nor was it marked for special handling. It was simply treated as non-essential. Paper without a home in the official taxonomy. This classification did the real work. It allowed the institution to claim completeness while quietly narrowing the scope of what completeness meant. The effect of these alterations was cumulative. First, the public-facing record was cleaned. Second, the internal residue was displaced. Together, they produced a single accessible narrative. When someone later asked what happened in that courtroom, the answer would be shaped by what could be retrieved, and what could be retrieved was now singular. There was only one version that mattered, and it was the version that carried no risk. The consequences were immediate in legal terms. Probate practice relies on the record not only as evidence, but as boundary. Arguments are framed by what the file contains. Appeals are constrained by what the minutes acknowledge. By omitting the testimony from the final entry and reclassifying the auxiliary copy beyond the index, the department ensured that the testimony lost practical legal force. It could not easily be cited. It could not be readily authenticated through the usual channels. It became, at best, an external artifact. Interesting, perhaps, but detachable from the proceeding it described. This alteration also had a social consequence that aligned with the pressures described earlier. A clean record insulated the families involved from renewed scrutiny. It prevented the case from acquiring an afterlife in the press. Journalists consulting the archive would find nothing to suggest a buried exchange. Attorneys considering later challenges would encounter a file that appeared complete and uncontroversial. The alliances that depended on continuity remained undisturbed. The cost of reputation, so carefully managed in the 1890s, did not compound over time. What is important here is the precision of the change. Nothing dramatic was added, nothing obvious was removed from view. The department did not falsify a judgment or invent a new outcome. It altered the accessibility of information, which is often more powerful than altering information itself. By deciding where a document lived and whether it could be found, the department reshaped reality without announcing that it had done so. This is why the period 1898 to 1899 is critical. It marks the transition from a decision to a system. Once the final minute entry was set and the auxiliary copy displaced, the alteration became self-sustaining. Future clerks would inherit a file that looked orderly. Future reviews would confirm that order by reproducing it. The absence would no longer feel like an absence. It would feel like normalcy. There is a temptation to imagine alteration as a moment of overt tampering. In practice, it is more often a sequence of small administrative acts that point in the same direction. A page is finalized, a reference is omitted, a copy is shelved where no one looks. Each step is defensible on its own. Together, they ensure that only one story can be told from the archive. The investigation advances here because the change is now material. We can see what moved in the real world, a minute entry rewritten, a document reclassified, an index left intentionally incomplete. These are not abstractions. They are actions with consequences. They explain how a testimony can exist and yet not matter, how a voice can be heard and then neutralized by paperwork. The tension that remains is quiet but sharp. If only one version remains accessible, then the archive itself becomes an instrument of selection. The question is no longer whether the testimony occurred, but who controls what can be found when history is consulted. The closing image is therefore practical and restrained, a storage room shelf inside the records department, labeled and orderly, while a thin folder rests unindexed among auxiliary materials, paper present but effectively unreachable, waiting for the next stage of the story when absence begins to produce winners. By 1899, the practical effects of the altered record were no longer theoretical. They materialized in the one place where silence is converted into advantage, the distribution of property. With the preliminary testimony absent from the official minutes and the auxiliary copy displaced beyond the indexed archive, the file presented itself to the surrogate's court as stable, uncontested, and procedurally complete. That stability created a narrow channel through which the estate could move quickly, without reopening questions that might have complicated ownership or delayed transfer. In that channel, the beneficiary became visible, not as a villain, not as a schemer, but as the party who stood to gain from the absence, because the absence simplified everything. The beneficiary was the direct heir, operating under the supervision of a legal trustee, whose role was to consolidate assets and execute the succession efficiently. In Gilded Age probate practice, this arrangement was common. Trustees were not neutral observers. They were managers of continuity. Their mandate was to preserve value, avoid fragmentation, and protect the estate from external pressure. When a record appeared clean, their work became easier. When a record hinted at unresolved testimony, their work became risky. In this case, the record they received contained no such hint. The minutes acknowledged no destabilizing witness. The docket reflected no unresolved issue. The trustee could proceed as if the estate had spoken with a single voice. The action that followed was concrete and measurable. redistribution of assets without contest. Properties that might have been subject to inquiry, real estate holdings, income-generating leases, and liquid investments were consolidated under the heir's control according to the approved plan. There was no pause for adversarial review. No competing claims surfaced in open court because nothing in the official file invited one. The trustees' filings moved through the system with administrative speed. Each step relied on the same premise: the record was complete. And because the record was complete, there was no procedural basis to slow the process down. This consolidation had a compounding effect. Once assets were transferred and titles confirmed, the cost of revisiting the case increased sharply. Challenging a distribution after the fact is always harder than contesting it during the process. It requires reopening files, questioning settled transfers, and confronting the presumption that the court's work is finished. By allowing the estate to close swiftly, the silence embedded in the minutes protected not only the heir's immediate gain, but the durability of that gain. Property, once redistributed, acquires inertia. It moves into new arrangements, new contracts, and new expectations. Each additional step makes reversal less likely. The trustee benefited institutionally as well. A smooth administration reflects competence. Trustees are evaluated, informally but persistently, on their ability to close estates without scandal or delay. A file that ends cleanly enhances reputation. It signals that the trustee can manage sensitive matters discreetly, a valued skill among families whose wealth depends on predictability. In this sense, the silence served two beneficiaries at once: the heir, who received consolidated assets, and the trustee, who reinforced a professional standing built on quiet efficiency. What did not happen is as important as what did. There was no extended hearing on competing narratives, no public airing of internal disagreement, no opportunity for the press to frame the estate as divided or unstable. In 1899, newspapers remained alert to probate drama, and an open contest could have invited scrutiny far beyond the courtroom. The absence of contest deprived journalists of material. With nothing on the record to suggest controversy, the story ended where most such stories end: inside the courthouse, without echo. The consequence of this sequence was the rapid closure of the succession process. Closure is an institutional outcome, not merely a procedural one. It signals that the court's interest has ended, that its attention has moved elsewhere, and that the file has entered the category of settled history. Once closed, a case becomes harder to disturb. Motions to reopen face skepticism. Requests for review encounter procedural barriers. The presumption shifts from inquiry to finality. That shift is not abstract. It shapes how future actors, lawyers, judges, clerks approach the file if it ever resurfaces. From the perspective of the beneficiary, this finality was the real prize. Property gained in a contested environment carries a shadow. Property gained in silence appears earned by right. The difference matters socially. In elite circles of the era, legitimacy was as valuable as liquidity. Consolidated assets could be leveraged, invested, or pledged without the lingering question of whether they were the product of unresolved dispute. The silence that began as an omission in the minutes ended as a reinforcement of standing. It is important to note that the beneficiary did not need to engineer the omission to profit from it. Benefit does not require authorship. It requires alignment. The heir and trustee operated within the conditions presented to them. The file they received told a story of procedural clarity. Acting on that story was not only rational, it was expected. The system rewarded those who moved decisively when the record permitted decisiveness. In this way, the silence functioned like an invisible subsidy. It reduced friction, it lowered risk, it accelerated transfer. The investigation advances here because the silence now has a measurable outcome. We are no longer dealing only with altered paper or displaced documents. We are dealing with property that changed hands, with authority that consolidated, and with a process that ended sooner than it otherwise might have. The beneficiary is not identified by name but by result. Whoever controlled the assets after 1899 did so in a landscape shaped by omission. The silence cleared the path, and someone walked it. The broader implication is institutional. When silence produces winners, it becomes attractive. It teaches the system which behaviors are rewarded. A probate process that closes smoothly is praised. A trustee who avoids conflict is valued. An heir who emerges uncontested is accepted. Over time, these incentives do not remain isolated. They inform how future cases are handled, how much detail is deemed necessary, and how aggressively records are maintained. Benefit, once realized, becomes precedent in practice, if not in law. The closing image here is not dramatic because benefit rarely announces itself. It is a clerk's stamp marking the estate closed, a trustee's ledger balanced and signed, a set of property deeds refiled under a single name. The room is orderly, the shelves are quiet, and the absence that made this outcome possible is now embedded in the result, setting the stage for what follows. Because when silence delivers advantage, the next question is not who benefited, but what else quietly disappeared to make that benefit secure. Between 1900 and 1910, the case did not need another hearing to become harder to challenge. It only needed the last remaining pathways to the witness to quietly stop working. That happened inside a system most people never think about until they need it. The County Records Index, the cross-referenced machinery that tells you where a name lives inside a courthouse archive. Minutes can be thin and files can be clean, but an index is supposed to be stubborn. It preserves access even when paper is scattered. It is the map that makes retrieval possible. And in this period, the map was altered in a way that produced a specific disappearance. The witness's name stopped existing in the places where it would normally be found. This disappearance was not theatrical. It did not involve a public order. It did not require anyone to deny that the witness had ever been heard. It worked through secondary references, the small administrative hooks that allow a future searcher to reconnect a person to a proceeding. In probate work of the era, names were typically discoverable through multiple channels: direct entries, cross-references, variant spellings, and see also lines that guided a clerk from one heading to another. When a witness appeared in a matter involving old money, those hooks mattered. They allowed a later attorney to locate testimony even if the minute entry was brief. They allowed a reporter to find what the court preferred not to advertise. They allowed a family rival to trace a thread that the official narrative tried to keep buried. In a functioning system, those hooks are redundant on purpose, because redundancy is how institutions protect continuity. What changed after the estate closed is that redundancy began to collapse. The first shift is visible in how indexes were maintained during the early 1900s. Periodic consolidation, recopying, and normalization of entries into cleaner internal forms. A county index was not a single permanent book. It was an evolving set of tools. Ledgers, draw cards, clerk-maintained registers, updated as workloads demanded. This created opportunities for a disappearance that looked like routine maintenance. A cross-reference could be dropped for clarity. A secondary card could be removed as duplicative. A marginal note could be left untranscribed when an older register was recopied. Each choice on its own would be easy to justify. Together, they could erase a person's accessibility without altering the underlying case file. By 1904, in the kind of administrative sweep that quietly happens in crowded record offices, cross-references related to older probate matters were being reviewed for consolidation. The concrete action here is narrow but decisive. Secondary mentions were eliminated. Not the main entry for the estate, those typically remained because they anchored property transfers. What disappeared were the auxiliary access points, the witness's name under a separate heading, the see also instruction that guided a clerk from one book to another, the cross-index line that linked a preliminary hearing to supporting materials. A future clerk searching under the witness would no longer be redirected into the estate's universe. The witness's name, once a potential doorway, became a dead end. This matters because an index is not merely descriptive, it is operational. It controls what can be found through ordinary procedure. In the records environment we have been following, minutes cleaned, auxiliary copy displaced, this was the final sealing mechanism. The witness's testimony already lacked official visibility. The auxiliary copy already lacked an index anchor. If cross-references had remained intact, a persistent searcher might still have found the witness through a side route, a name card, a reference ledger, a clerk's see also. Once those side routes were stripped out, the system no longer offered any lawful, predictable way to reach the testimony by searching the witness's name. The witness could still exist on paper somewhere, but in practical terms, the witness ceased to exist as a retrievable fact. The disappearance is therefore specific, a name removed from cross-references, not erased from memory, not erased from the world, but erased from the institutional pathways that convert memory into proof. In an archive, access is reality. If an attorney cannot find a name through the recognized tools, that name has no procedural leverage. If a reporter cannot locate a witness through the index, the story never forms. If a later claimant cannot trace the witness to a proceeding, the claim cannot be anchored. The system does not have to argue, it simply fails to retrieve. From 1900 to 1910, the effect compounds. Because clerks and officers tend to trust their own instruments. If the index yields nothing, the assumption becomes that nothing exists. Searches stop. Staff conclude the inquiry is exhausted. This is not malice, it is workflow. In crowded public offices, what cannot be found quickly is treated as unlikely to exist at all. The witness's disappearance from the index therefore functions as a quiet boundary marker. It tells the institution, and everyone who relies on it, this person is not part of this matter. And once that belief is established, it becomes self-reinforcing. Future indexing practices mirror the earlier omission. New cross-references are not created because the system no longer recognizes a need for them. The most consequential consequence is plain and practical. It becomes impossible to trace the witness, not philosophically impossible, but procedurally impossible under normal courthouse use. A person could walk into the records office years later with a name and a date range and do exactly what the public is supposed to do: search the index, request a file, follow references, and still come away with nothing. The estate would appear complete. The minutes would confirm no witness. The index would provide no crosslink. The trail would end where official systems want trails to end, at a closed file, with no visible complication. This is the point where disappearance stops being a description and becomes an outcome with force. The witness is not only missing from a minute book, the witness is missing from the retrieval architecture that would allow the missing minute to be challenged. The system has removed the witness twice. First from the record that defines what happened, and then from the index that defines what can be found. That second removal is the one that makes the first removal durable. The investigation moves forward here by tightening the chain. We began with a proceeding that should have left a trace. We found an auxiliary copy that survived outside protocol. We located the internal decision that allowed omission. We saw the alteration that cleaned the accessible record and displaced the residue. We watched the beneficiary receive assets under that clean narrative. Now we reach the stage where the disappearance becomes structural. The witness's name is not simply absent, it is unsearchable. The system has arranged matters so that even a determined inquiry is forced to behave as if the witness never existed. The tension that resolves in this block is simple. After 1900, the case is no longer just quiet. It is sealed by the tools that define official memory. The public record doesn't need to argue with you, it only needs to fail to lead you anywhere. And by the end of the decade, the most fragile part of the case, the human voice that once entered the courthouse, has been stripped of the one thing a voice needs to matter in law: a trace you can retrieve. The closing image is a drawer in the records office marked with worn lettering, the kind clerks pull hundreds of times a day. The cards sit in tight order. A hand flips through surnames, pauses where a cross-reference should be, and moves on, because the witness's name is not there, and the index, calm and authoritative, offers nothing but empty space where the trail used to begin. In 1912, the first crack did not appear in the minute books or the court file, because those instruments had already been cleaned into coherence. The crack appeared where numbers have to remain defensible even when narratives are controlled. Inside the estate valuation office, the administrative unit that reviewed asset values for tax, settlement, and internal consistency. This office did not care about courtroom drama. It cared about whether the reported figures matched the property reality the city could see: land, buildings, leases, securities, and the expected income attached to them. And in that year, during a routine comparison of figures that should have aligned, someone encountered a set of values that simply did not sit comfortably inside the official version of the estate. The inconsistency was not announced as scandal. It arrived as a mismatch between two kinds of documentation that normally reinforce each other. On one side were inventories, lists of property and assets associated with the estate's administration, the sort of paper that is expected to be complete because it drives valuation. On the other side were court decisions and administrative dispositions, approved distributions, trustee acknowledgements, and the procedural endpoints that signal how the estate was resolved. In a stable file, these two sides mirror each other. The inventory reflects the scope of what is being distributed. The court's decisions reflect how that scope was handled. When the two do not mirror, it suggests that either the inventory is incomplete, the decisions were based on a narrower set of facts, or the values were adjusted to fit an administrative preference. The concrete action in 1912 was straightforward, a comparison between inventories and judicial decisions. The valuation staff looked at the recorded asset base and then at the outcomes the court had approved years earlier. The conflict was not that the estate was valuable, many estates were. The conflict was that the values implied by the inventory materials did not sit naturally with the clean, uncontested path described by the official record. Certain assets appeared to carry valuations that suggested they had been treated differently at different points in the file. Properties that should have been assessed consistently based on location, revenue, and market comparables seemed to fluctuate when traced through successive paperwork. Securities and holdings that would typically be itemized in a manner consistent with court-approved consolidation showed signs of having been aggregated with unusual simplicity, as if the file were designed to support a single smooth distribution rather than reflect the full complexity of ownership and claim. This is where inconsistency matters in an investigative chain. A clean record is supposed to be consistent not only in words, but in numbers. Numbers are harder to compress without leaving fingerprints because they are examined by different departments with different incentives. A probate clerk can keep minutes brief. A records department can classify paper outside an index. A county records tool can remove cross-references, but a valuation office must still reconcile property reality with what the paperwork claims. If the estate's official narrative says, in effect, nothing complicated occurred, then valuation flows should look normal. They should align with ordinary transfer behavior. When they do not, the file begins to betray the effort that made it look uncomplicated in the first place. The tension is not that the valuation office discovered proof of wrongdoing. The tension is that it encountered a mismatch it could not neatly resolve using the official story. And because this was 1912, the response was institutional restraint rather than confrontation. The estate had already closed. The beneficiary had already consolidated assets. The index had already been thinned of secondary paths. The cost of reopening such a matter would have been high, not only legally, but socially. A reopened estate can trigger ripples, title questions, trust complications, reputational exposure, and a renewed appetite from newspapers to revisit an old dispute. An office designed to maintain administrative stability would not rush into that risk without a direct mandate. So the inconsistency did what many institutional inconsistencies do. It produced a quiet internal suspicion without producing an official action. The staff could note the mismatch. They could question the file internally. They could ask whether valuations had been updated, whether certain assets had been treated under different assumptions, whether earlier inventories had been superseded. But without a procedural opening, without a complaint, without a new claim, without an instruction from a superior, there would be no case reopening. The system had already been trained to treat the estate as settled. The record had already been built to support that finality. That is the real consequence here: silent suspicion without reopening the case. This consequence matters because it shows the system encountering its own contradiction and choosing stability over excavation. It also strengthens the logic of the earlier alterations. If the witness's testimony had survived in the official minutes, if the auxiliary copy had remained indexed, if cross-references had preserved the witness as searchable, then a 1912 inconsistency would have had something to attach to. It could have been investigated through existing record pathways. Instead, the inconsistency existed in an environment where the pathways were already narrowed. There was no obvious lever to pull that would lead to a clean investigative route. The record offered closure, and closure discouraged curiosity. There is another practical dimension. In valuation work, discrepancies sometimes arise from ordinary causes: market shifts, changed assessments, or evolving accounting standards. The office could interpret the mismatch as an error and correct it internally without disturbing the legal file. That option, too, protects stability. It allows the institution to reconcile its numbers without admitting that the underlying record might be incomplete. In other words, an inconsistency can be neutralized by technical adjustment. The question becomes whether the mismatch is merely an administrative mistake or whether it signals an earlier adjustment that was deliberate, designed to harmonize the estate's public-facing story with the outcome the beneficiary needed. This is the limited reflection that the file permits at this stage, and it is the one the viewer is meant to hold. When numbers do not fit the narrative, the institution must choose between investigating the narrative or adjusting the numbers. In the early 20th century, especially in elite probate matters, The system often preferred to preserve closure. That preference does not prove intent, but it creates an environment where intent can operate safely, because later checks will tend to smooth rather than confront. The investigation advances here by adding a new kind of evidence, not a transcript or a missing name, but a misalignment in valuation logic that suggests the official version is too clean to be true. It places the contradiction in 1912 after the estate had been consolidated, when the benefits of silence were already in place. It also shows that the system had multiple opportunities to detect friction, but those opportunities did not necessarily produce public correction, because correction carries costs. The block ends with the practical tension that remains unresolved, because it has to propel the next topic. A valuation office can notice a mismatch, but it cannot easily pursue it if the retrieval architecture has been stripped of keys. That is what makes the inconsistency dangerous. It exists as a question without an accessible trail. The closing image is therefore administrative and precise. A valuation worksheet on a desk, columns of figures aligned in ink with one line circled, an amount that does not reconcile. With the court's clean disposition, while the case file beside it remains closed, stamped, and officially quiet, waiting for the moment when institutional risk becomes impossible to ignore. Between 1910 and 1920, the most dangerous aspect of the file was no longer the missing minute entry itself. It was what that absence implied if it became legible to the wrong audience at the wrong time. By the second decade of the 20th century, New York's old money ecosystem had matured into something more interlocked and more fragile than it had been in the 1890s. Families were not merely wealthy, they were networked through trusteeships, bank boards, charitable institutions, and political relationships that depended on the appearance of lawful continuity. In that environment, a probate irregularity was not a private embarrassment. It was a potential destabilizer, because it raised a question that the era's power structure could not tolerate in public, whether legacy was being protected by law or by selective memory. The risk of scandal in this period came from the convergence of two forces. The first was the increasing sophistication of financial press and business reporting. The public was reading not only society columns, but market coverage that treated institutions and elite families as part of an economic system. A probate case tied to significant property holdings could interest more than gossip writers. It could attract financial reporters who understood that inheritance disputes affect titles, trusts, and banking stability. The second force was the political climate of the progressive era, when reform rhetoric made the public more receptive to stories about elite privilege and institutional bias. If a credible narrative formed around a missing testimony and a cleaned record, it would not remain contained inside the courthouse. It could become a broader indictment of how the system functioned. That is why, in this window, the crucial action was not a new alteration of paper, but the maintenance of the case outside public debate. This maintenance did not require a censorship order. It required coordination by omission, keeping the file from becoming searchable, keeping secondary references thin, keeping the narrative closed, and most importantly, ensuring there was no procedural event that would attract attention. In practical terms, this meant the matter remained settled on paper and undisturbed in court. The absence of a reopened proceeding mattered more than any private suspicion inside an office, because reopened proceedings generate their own publicity. They create filings, minutes, dates, and hearings. They invite questions. In a city where reporters watched courthouses, a reopened estate could become a story before anyone controlled the angle. The alliances at stake were not vague. They were concrete and institutional. Banks that financed development and underwrote business activity depended on the stability of collateral. Estates often held property that was leased, mortgaged, or quietly used as security for larger financial arrangements. Trustees managed not only the distribution of assets, but the ongoing stewardship of wealth, including relationships with lenders and investment houses. If a scandal suggested that a major estate had been administered under an incomplete or manipulated record, the consequences could spread outward. Title certainty could be questioned, trust structures could be scrutinized, and counterparties could reconsider exposure. Even the hint of instability could be costly. Families had their own reasons to prevent escalation. Elite social standing in this period was not only cultural, it was functional. It determined access to partners, to marriages, to club networks, and to political influence. A probate scandal was dangerous because it could reveal not just a legal disagreement, but a moral fracture. Hidden heirs, suppressed testimony, internal coercion, or any version of the story that implied that public respectability was being maintained through private control. Such narratives had leverage precisely because they did not need to be proven to cause damage. They only needed to be plausible enough to circulate. Political circles also had reasons to avoid being pulled into it. In the 1910s, city and state politics were sensitive to accusations of institutional favoritism, and courts were part of that field. A public revelation that a probate file appeared clean, while a surviving copy suggested omitted testimony could be framed as evidence of systemic accommodation for the wealthy. That framing could attract reformers, rival political factions, or anyone seeking to attack an administration. The courts, in turn, had an incentive to preserve the appearance that probate work was routine and fair. They could not afford a public narrative suggesting that clerical discretion functioned as a shield for influential families. This is the core risk. Once the story becomes public, it stops being about a single witness. It becomes about institutional credibility. The claim would not be merely "a testimony is missing." It would be "the system can choose what counts as the record." That is a larger accusation, and it threatens more than one estate. It threatens the legitimacy of the archive itself. In that context, the safest institutional response was to keep the file inert. No new proceedings, no new entries, no new hooks for inquiry. The mechanics of keeping the file inert are administrative rather than cinematic. A clerk does not create a new index entry. A registrar does not restore a cross-reference. An internal doubt is recorded as a technical note rather than a formal challenge. A valuation discrepancy is handled through adjustment rather than escalation. Each of these acts is small, but their effect is cumulative. They ensure there is no event that forces the system to speak publicly about what it prefers to keep quiet. The consequence of this strategy is the one the topic requires: stability preserved at the cost of truth. That cost is not moralizing, it is structural. The estate's distribution remains intact. The beneficiary's position remains secure. Trustees continue to manage consolidated assets without fear of reopening. Banks and counterparties continue to treat titles and holdings as settled. Political relationships remain untested, and the public record remains a smooth surface. But stability has a price, and during 1910-1920, that price was paid through continued institutional silence. A silent suspicion, like the one implied by valuation mismatch, can exist in a bureaucracy without forcing action as long as there is no external trigger. The system can choose to treat the mismatch as error, the missing trace as irrelevance, the auxiliary copy as an orphan document. That choice protects alliances. It also deepens the separation between what happened and what can be proven to have happened. The Investigation advances here by clarifying why the story could not safely surface in this period, even if someone inside the system noticed something wrong. The file was not merely inconvenient, it was dangerous. It threatened to implicate not only a family, but trusteeship practices, indexing norms, and the credibility of courthouse record-keeping. In a decade when reform sentiment and financial journalism could combine into a powerful spotlight, the simplest defense was to deny the spotlight an event to focus on. No reopened case meant no public timeline. No public timeline meant no narrative momentum, and without narrative momentum, the courthouse remained the final gatekeeper of what the city could know. The closing tension is therefore resolved in the only way institutions often resolve it, by choosing quiet continuity over disruptive correction. The story is held in place, not with a lock you can see, but with a series of administrative non-events that prevent inquiry from gaining traction. The image to end on is concrete and restrained. A courthouse corridor in the late 1910s, a clerk's desk stacked with active files, while an older estate folder sits closed in a cabinet, its minutes clean, its index pathways thin, its contradictions contained, not because they were answered, but because the era could not afford the scandal of asking the question out loud. By 1924, the most effective kind of concealment was no longer a one-time omission or a single displaced document. It was the transformation of omission into policy language. What began in the late 1890s as an internal choice about what should enter a minute book had, over the decades, been absorbed into a broader institutional habit, the habit of describing absence in terms that sounded like routine preservation. In that year, within an archival preservation policy framework, the courthouse's approach to sensitive paper was increasingly managed through categories that did not explain themselves, but did not need to. They were administrative words that carried authority while refusing clarity. This normalization did not require anyone to write, "We hide things." It required the adoption of terms that performed the same function without inviting challenge. By the 1920s, records departments were modernizing, reorganizing holdings, and implementing preservation practices meant to protect aging material and manage public access. Those practices were real and, in many cases, necessary, but they also created an ideal cover for ambiguity. A file could be moved, a reference could be thinned, a set of papers could be separated, and the reason could be expressed in language that sounded responsible. Maintenance, classification, restricted. Each term implied legitimacy. None of them disclosed intent. The pivotal change in 1924 was not the invention of restriction, but its standardization. When restriction becomes standardized, it becomes unremarkable. It no longer needs a special justification each time it is applied. It becomes a default setting available to administrators whenever a file is sensitive, incomplete, not for routine handling, or simply inconvenient. The concrete action in this topic is therefore structural, the standardization of documentary ambiguity. The policy environment encourages staff to treat certain records as category problems rather than factual problems. Instead of asking, "Why is this missing?" the institution asks, "How should this be classified?" That shift matters because classification is a management tool, not an explanation. Within such a policy environment, a file like this one becomes easy to maintain without ever confronting its contradictions. The minute books remain clean, the indexed pathways remain thin, auxiliary materials remain outside normal retrieval, and if anyone inside the system notices a mismatch, like the valuation inconsistency detected earlier, the policy language offers a way to contain the discomfort without escalating it. A clerk can describe a gap as maintenance-related, An archivist can say a set of papers has been reclassified. A supervisor can mark an item restricted to prevent unnecessary handling. No one has to argue about whether a witness existed. They only have to manage access to whatever might suggest it. This is how silence becomes procedure. The institution stops treating silence as an anomaly and starts treating it as a feature of careful record stewardship. A missing cross-reference is no longer a problem. It is an outcome of index maintenance. A displaced transcript is no longer suspicious. It is auxiliary material kept outside the main series for preservation reasons. A lack of protocol number is no longer alarming. It is unprocessed or not accessioned, terms that suggest pending administrative work rather than purposeful displacement. The policy vocabulary cushions everything. It turns questions of truth into questions of handling. What makes this normalization especially powerful is that it is forward-looking. It shapes how new staff are trained and how future decisions are made. A young clerk or archivist entering the department in the 1920s inherits not only shelves and boxes, but categories. They learn that some materials are restricted, that some files require special handling, that some references are classified in ways that do not require explanation to the public. Over time, that learning becomes muscle memory. It reduces the likelihood that anyone will experience the file as strange. The absence does not feel like an absence. It feels like compliance with procedure. This is why the year 1924 matters as an institutional marker. It represents a point when record-keeping is increasingly professionalized and systematized. Systematization is usually framed as a protection against arbitrary handling. In practice, it can also protect arbitrary handling by burying it under standardized terminology. If a file is restricted, the restriction itself becomes the explanation. If a document is reclassified, the reclassification becomes the end of the discussion. And because the terms are vague, they can be applied without contradiction. Maintenance can mean preservation, or it can mean removal from access. Classification can mean organizing, or it can mean isolating. Restricted can mean legally protected, or it can mean simply inconvenient. The consequence is exactly the one the topic requires. Silence begins to look like normal procedure. That consequence is not merely cultural, it has operational impact. When silence looks procedural, it stops triggering escalation. Public inquiry is redirected, restricted. Staff questions are answered, maintenance. Requests for specific papers are delayed, classification. Each response is plausible. Each response reduces pressure. And because the responses are standardized, they become hard to challenge. Challenging them requires a person to demand specificity, and demanding specificity in a courthouse context can be interpreted as disruptive, suspicious, or unnecessary. This normalization also protects alliances indirectly, without needing explicit coordination. Banks and trustees benefit from stable archives because stability supports titles and trust operations. Families benefit because their legacy remains unruffled by reopened questions. Political actors benefit because the courts do not become a platform for renewed allegations of favoritism. The policy does not need to name these beneficiaries. It only needs to maintain an environment where reopening old disputes becomes administratively discouraged. Vague terms do that quietly and effectively. The investigation advances here because it shows that the concealment mechanism has evolved. We are no longer looking at a single missing line or a single removed reference. We are seeing a language system that makes future concealment easier and makes past concealment harder to detect. Once ambiguity is normalized, it becomes difficult to distinguish between legitimate preservation choices and strategic access management. That is the point. The policy environment blurs the line, and the blur becomes protection. There is a limited reflection that the file permits at this stage, and it is the one that matters for the viewer. When an institution learns to describe gaps as categories, the gaps survive indefinitely. No one needs to actively hide them every year. They remain hidden by default because the system has built a vocabulary that keeps them from being treated as questions that require answers. The closing tension resolves into a simple administrative fact. By the mid-1920s, the courthouse does not need to erase the witness again. It only needs to keep the surviving fragments inside the correct category. The image is concrete and restrained. A paper folder in a storage area, stamped with a plain designation, restricted, and beneath it a smaller note in institutional handwriting, maintenance, classification. The words are ordinary, the effect is not, and it prepares the next topic because once silence becomes routine, the only remaining question is what survives into our own time and what the institution still refuses to explain. In 2026, the case no longer lives only in bound volumes and drawer cards. It lives inside a modern promise that digitized public records make the past searchable, accountable, and harder to manipulate. And yet, the most revealing lesson of this file is that technology can widen access without restoring what an institution decided not to preserve. The record does not become truthful because it becomes digital. It becomes faster, it becomes cleaner, it becomes easier to retrieve what the system already recognizes as retrievable. And that is precisely why this story still matters now. Public archives today are filled with scanned pages, indexed entries, and metadata fields that look authoritative. They allow anyone to type a name, a year, a courthouse, and expect the machine to surface the relevant paper. But digitization is not resurrection, it is translation. The scanner translates what survived, the index translates what can be found, and the case we have been following was designed step by step to survive in a narrow and controlled form. The minutes were cleaned, the auxiliary copy was displaced, the cross-references were thinned until the witness became untraceable. By the time ambiguous archival language became standard practice, the absence had already been institutionalized. Digitization inherited that structure, and in 2026, it reproduces it. The named entities have changed in appearance, but not in function. The old Lower Manhattan record rooms have modern interfaces. The public digitized archives offer online portals, request systems, and remote access policies. Yet when you search for the witness, by name, by variant spelling, by category, the system behaves the way it was trained to behave for over a century. It returns nothing that confirms the witness existed as a procedural fact. The official narrative remains intact because the official narrative is what the index recognizes. It is what the scanner captures. It is what the database is built to serve. The concrete action in the present is therefore not dramatic. It is a search and a request that should work, but does not. A user consults the digitized minute books for the relevant window in 1898 and finds the same clean entry we described earlier. They query the case through the searchable interface and receive a stable, uncontested pathway, docket endpoints, basic administrative notes, and nothing more. They submit a request for supplementary material and receive a response framed in modern versions of the old language. Access limitations, preservation considerations, classification status, restricted handling. The words have been updated, but the effect remains the same. The file is available in the version the institution has normalized. The version that complicates it remains outside ordinary reach. This is not a claim that modern archives are malicious. It is an observation about systems. A digitized archive depends on metadata, and metadata depends on classification. The archive cannot easily surface what it cannot label. The database cannot retrieve what is not indexed. When a document was deliberately kept outside official indexing, modern search tools become blind to it. They do not fail loudly. They fail quietly, returning a clean absence that looks like certainty. That is why technology can strengthen institutional silence rather than break it. It makes the silence efficient. The official narrative also remains intact because it aligns with what institutions are comfortable certifying. A clean file is easy to publish. It is safe. It exposes no internal contradictions. It requires no staff explanation. It is, in administrative terms, complete enough. And completeness is often defined not by what happened, but by what the record contains. That circular definition becomes harder to challenge in digital form because digital presentation carries the aura of totality. A scanned page feels final. A database result feels exhaustive. A no records found message feels definitive. In reality, it may only reflect what the system has been built to reveal. The consequence in 2026 is therefore direct and unresolved. The fundamental questions remain unanswered, not because the questions are unclear, but because the retrieval pathways were dismantled long before computers existed. The witness's testimony still exists only as a survivor on the margins. An auxiliary object that is either physically inaccessible, administratively restricted, or practically unfindable through the tools the public is given. The valuation mismatch still reads like friction without leverage, because the legal file remains settled and protected by procedural finality. The beneficiary's consolidated outcome remains stable because stability was engineered into the record, and the record is what modern institutions are willing to reserve. This is where the present forces a sharper perspective. We live in a time when people assume transparency is a default. We assume that if something happened, there will be a searchable trace. But this case shows the opposite. If an institution chooses early enough to keep a fact out of the official record and then removes the access points that would allow retrieval, that choice can persist across centuries. It does not require ongoing conspiracy. It requires maintenance, classification, restricted handling, the same procedural vocabulary, now delivered through email templates and website policies instead of stamped folders. The investigation advances here because it clarifies the modern stakes. The story is no longer only about what happened in 1898. It is about what our era can and cannot recover when an older era built a record to be selectively complete. The digitized archive offers more access than any person in 1912 could have imagined. And yet it still cannot answer the simplest question a serious inquiry would ask. What was said under oath when the witness was heard, and why did the official minutes refuse to acknowledge it? The archive cannot answer because it has inherited an absence that was made procedural. What remains intact is the official version of legitimacy. The estate's closure still stands. The consolidated outcome still reads as lawful continuity. The institutional surfaces still present calm, and what remains intact with it is the uncertainty that matters. If a single testimony can be removed from official memory and remain unrecoverable even after digitization, then the public record is not merely a storage of history. It is a mechanism that decides which history becomes provable. The closing image must be concrete because the present is concrete. It is not a candle-lit archive. It is a modern screen showing a search field, a case number, and a clean set of results. Under minutes, the entry is brief and silent. Under related documents, there is nothing. Under supplementary materials, there is a note. Access limited due to classification or preservation. The interface looks modern. The absence looks normal. And that is the unresolved tension the present cannot dissolve, because the silence has been translated, not corrected, and the system still refuses to tell you what it once heard. The record ends the way many institutional stories do, not with a verdict, but with a door quietly closing. In the final accounting, there is no dramatic stamp that declares deception, no formal rejection of what was once spoken under oath. There is only the calm authority of preserved paper and the deeper authority of what was never allowed to remain. Archives do not merely safeguard the past, they shape it. They decide which voices are carried forward and which are allowed to dissolve into administrative air. Within the public record system, omission is often treated as neutrality. Pages are filed, volumes are bound, indexes are finalized, and in that process, absence acquires the weight of fact. What cannot be found becomes what did not matter. What did not matter becomes what never existed. This is how a truth can be rendered legally invisible without ever being formally denied. The system does not need to argue with it. It only needs to proceed. Over time, corridors empty and footsteps fade. Documents are returned to shelves, folders slip into storage, and light retreats from the deeper rooms. The machinery of record-keeping continues to hum, precise and untroubled, while a narrower version of history circulates as certainty. In that narrowed version, the process appears complete. Estates are settled, titles are secure, the narrative holds. Yet beneath that surface lies a different inheritance, the knowledge that what survives is not always what occurred, but what was permitted to endure. This is the institutional moral left behind in these halls. Power does not always announce itself through signatures or decrees. Sometimes it works through restraint, through the choice not to write, not to index, not to preserve. An omission can be as consequential as any recorded act, because it determines what future generations are allowed to prove. When the archive chooses silence, it converts uncertainty into order, and order into permanence. As these doors close, remember that this is not an isolated passageway. Beyond it, there are other rooms, other files, other ledgers whose calm surfaces conceal unresolved questions. If you choose to remain with us, subscribe so that you're here when the next sealed door finally opens. Leave your thoughts below. Every perspective helps illuminate what history tried to bury. And if this story resonated with you, let us know. Your signal tells the algorithm these forgotten halls are worth exploring again. If you are willing to step deeper into the shadows, the next chamber awaits. Some secrets survive, not because they were never challenged, but because those who feared them ensured the record would never learn how to speak.